Just give me a second here. Okay. Could you do a roll call, Mr. Nibbs, please?
Excuse me?
So I'd like to call the meeting to order. So could you do a
Okay.
roll call?
Trustee Colwood? Absent. Trustee Dorsey?
Present. Morning.
Trustee Liger?
Yeah, present.
Trustee McDonald? Absent. Ex officio member Cindy Richardson? Absent. Trustee Russell?
Present.
Trustee Smith? Absent. Chairman Barry?
Present.
The chair, 4 present, 4 absent, which includes the ex officio member.
Ex official member point information, Chair. Ex official member is being sworn in today. She would be excused.
So I have a correspondence to that point.
Yeah, I did see that correspondence, so we'll mark as excused. Thank you, Trustee Dorsey. Okay. We'll begin with the next item on the agenda, which is comments and suggestions from retirees. Hearing none. Comments and suggestions from active members. Hearing none. Secretary's minutes.
Mr. Chairman, before Secretary minutes, I would like to announce that I have to leave at 12. And I would like for us to reorder our agenda so that we could go in executive session to deal with the lease and unfinished business before we participate with the full agenda, because I do have to leave. And I apologize to the members and everybody, but I'd like to deal with that kind of business in executive session first, if we could, please. So I move that we move into executive session.
Attorney Smith, could you?
All right, second it.
Mr. Chairman,
Yes.
the lease cannot be discussed right now because the individuals are not available right now. We have them available at 11:30 VI time.
Well, just for a point of information, Chair, I also have a short day today around noon. I'll be out of here as well.
Oh,
Okay, so
well,
could we, Mr. Nibbs, is there a way you could, I guess we could start for a minute, but with the intention of switching to executive session when the earliest opportunity that we could get folks. Is it possible to get them?
I think you're on mute.
I'm sorry, I said I'll call them right now and see if anybody's available in the next half an hour.
Okay, so could we go ahead with the agenda as is for the moment, Mr.?
yes.
Mr. Russell? Clendenin also, I guess, if she's on, she could try to reschedule the time for the search firm to be available.
Trustee Bory, good morning to everyone. They're in Colorado. I think they're 3 or 4 hours behind us. So right now it's almost like 5 a.m. So I can't call at this time. So I'm gonna have to wait for a little time to pass, and then I'll reach out to them to see if they can come on earlier.
Okay. Okay, so
One information, Chair.
Yeah.
That search group, if you can send them an email, somebody might see that up to now, as opposed to just calling.
I'll
Yeah.
do both. Thank you.
Yeah, yeah. Okay, so we will see how far we get to the agenda, Trustee Russell, and at the time when we'll just switch, we'll make the change in the agenda at that point in time.
Okay,
Okay,
Mr.
sure.
Chairman, I spoke with JLL and they will be available to log in at 10 o'clock our time.
Okay. All right, so that's one.
That's good.
Okay. So let's move on with the agenda as is for the moment.
Yes.
Okay, so Secretary's minutes. Any questions about the minutes? I guess, assume you read it. You have a motion to accept the minutes?
Motion, Mr. Chair.
Yeah,
Motion, Mr. Chair.
yeah,
The
yeah.
minutes separately, Mr. Chairman.
I move that we accept the secretary's minutes from the January 27th regular board meeting. I so move.
I can,
Move that second then.
Already, let me go.
You have a roll call?
Trustee Colwood,
Yes.
trustee Dorsey,
yes,
trustee Liger,
Yes.
trustee McDonald, absent, trustee Russell. Trustee Russell. Absent, trustee Smith. Absent, Chairman Barry.
Yes.
Four
Yes,
yes.
that's a yes for me. That's a yes for me. Okay?
Okay.
5 yes, 2 absent.
Okay, so those minutes have been accepted.
Motion, Mr. Chair.
Yes, go ahead.
I move that we accept the secretary's minutes from the special board meeting held on January 28th. I so move.
I can,
More than seconded, roll call?
Trustee Colwood,
Yes.
trustee Dorsey,
yes,
trustee Liger,
Yes.
trustee McDonald, absent, trustee Russell,
Yes.
trustee Smith, absent, Chairman Barry.
Yes.
5 yes, 2 absent.
Motion, Mr. Chair.
Yes, motion on the
I
February
move
8th.
that we accept the secretary's minutes from the special meeting held on February 8th, 2022. I so move.
second,
Moved and seconded. Roll call?
Trustee Colwood,
Yes.
trustee Dorsey,
yes,
trustee Liger,
Yes.
trustee McDonald, absent, trustee Russell,
Yes.
trustee Smith, absent, Chairman Barry.
Yes.
Chair, 5 yes, 2 absent.
Motion, Mr. Chair.
Yeah, go ahead, motion.
I move that we accept the secretary's minutes from the special board meeting held on February 11th, 2022. I so move.
well, I wasn't there at that meeting, so. I wasn't there.
We got a second.
I don't recall if I was at the meeting either. I don't think I was. But I'll second it.
Okay. Roll call?
Trustee Colwood,
Yes.
trustee Dorsey,
Not voting,
trustee Liger,
Yeah.
trustee McDonald, absent, trustee Russell,
Yeah.
trustee Smith, absent, Chairman Barry.
Yes.
4 yes, 1 not voting, 2 absent.
Okay. Um, So we'll move to the next item on the agenda, which is scrolling back here. Give me a minute. Communications and correspondences.
Good morning. We have a few pieces of correspondence. The first one is a letter dated January 20th, 2022 to Mr. Andrew Smith from the CEO, the new CEO of the VI Water and Power Authority. It was a letter, welcoming him to the authority, and also letting him know about the situation that we have regarding the payments of contributions. It's on the screen. I'm just scrolling it up. We let him know what the periods were and the amounts. And also we asked for a meeting with him, which we did have, and we have memorialized it in a subsequent correspondence to him. Next correspondence is a notice from correspondence from the Department of Planning and Natural Resources regarding our request for rezoning of the property at Havenside Mall. I'm glad to announce that they support the effort. There was no public opposition, and we are presently in the scheduling of hearing before the legislature. This is the correspondence from Ms. Cindy Richardson indicating that she will not be attending the meeting today because she's being sworn in. And we'd like to congratulate her.
Right,
Next piece of correspondence is, excuse me?
I was saying, I think we are losing you a little bit, at least I was.
Oh, next correspondence is a letter dated the 16th of February to Mr. Smith, Andrew Smith, of the Chief Executive Officer of WICO. We did meet with him on February 15th. It was a very frank meeting. I think he understands. Seemed like he did his homework. He understands what the problems are. He's willing to rectify the obligations to the GRS. We gave him notice that he needed to at least make payment on the employee deductions, which include loans and contribution loans also. So and that was submitted to the board. A copy was submitted to the board, and these are the amounts that are due from WAPA. We are more concerned right now with the employee contributions and employee deductions. So which adds up to about $1.9 million. And it's here in the letter. Okay, so we are waiting a response from him to enter into an installment payment plan for the employer's portion and all the accumulated interest and fees. He understands this, and we asked him to remit to GRS within 10 days. 10 days is the 26th. The deductions and employer contributions that we said that are due right now, and payment, come up with a payment plan for those over the next 12 months, beginning March 1, 2022. We are waiting response from him.
Mr. Chair, if I might, Mr. Nibbs, what is the time frame for WAPA's response, given that we anticipate the agreement would commence March 1st?
10 days from February 16th, which is the 26th.
Okay.
We have not heard any, so far I haven't seen anything coming in from him. We'll probably follow up today. with him to remind him that he needs to respond. That ends the reading of the correspondences.
Point of information, Chair.
Go ahead.
Mr. Nibs, if there's no response over this period, what is the next move for the system at that point?
Our conversation with Mr. Smith, he is willing to come up with a plan. I'm very reluctant because we went this road before with WAPA. We filed a lawsuit about 10 years ago. The court asked us to mediate, which we did. We also have to remember that we are asking WAPA to assist us in a big way with our issues over at Havenside Mall. So all I'm saying is that if we can get a payment plan, we're trying to see if we can get a payment plan. I don't want to entertain any lawsuits at this time.
I hear what you're saying. I was just asking what was next if the payment doesn't come into play, because either way, you have your situation on the dock.
Well, we'll make that decision when we get to it, but I'm reluctant because we go to court, they're going to tell us the same thing, try to mediate. So if we don't work with him, if he can't pay it in 12 months, then he have to maybe be able to pay it in, but you know, we're not going to stop the running of the interest and the late fees. So it'd be better for him to pay faster. So come up with a payment plan that is, 12 months, but no more than 12 months, because the interest is going to continue to run. Plus, he must pay also the current employer contributions in addition to the late payments. So I'm trying to be as we're trying to work with them, and he seems he's very open and he's willing, and he understands the situation, and he knows that it was wrong, and especially with employee deductions, and so I think we should go that route first. If he doesn't respond to us, then we will make a decision what to do.
I thought we already had a resolution on this issue, but
yes, as a resolution. So, but I'm telling you, it's you have to be careful, because we file a lawsuit back to mediation again. He may say he can't pay within 24 months. And also, I just said they are assisting us in a great way with our situations over at WAPA. So, over at Havenside Mall, my concern is the employee deductions at this time, and come up with a payment plan for the employer portion, plus the current amounts being deducted. So if he can start paying the current amounts upfront to stop the running of interest, and maybe ask for an extended period for the late payments, fine. But we have to come to a resolution. I can't force his hand because they are assisting us in a mighty way. Many times, ways that we want to accomplish what we want at Havenside Mall. My concern is the employee deductions, because you cannot make deductions from employees' salaries and not remit them to the agency.
So, Mr. Nibs, in light of what you're saying and the issue Trustee Dorsey raised about the existing resolution, it seems to me that at some point you would want to recommend to the board that it either vacate or it reconsider that resolution, because if nothing is done, then you'll continue to be in a continuing violation of the board's resolution, and you don't want to be in that position. So the board, assuming the board agrees with you, would probably want to act on that, either to stay, vacate it, modify it, and do something so that it empowers you to do what you're suggesting and that you're not in violation of the board's resolution.
Yes, I understand that. And yes, I understand you very clearly. That's something I'll have to discuss with General Counsel.
Let's talk about it, because that's I'm not sure if that's a General Counsel issue. My personal take on it is that as a board, I think we've sent a message to the staff, and if they needed one at all, that we, as a board, we expect them to be aggressive in going after amounts due. However, at this point, I'll be willing to ask the board. I suggest that the board give Mr. Nibs some room to negotiate further, given we have a new player on the scene. And given, I think we all know the reality of WAPA in their fiscal situation. And if we could work something out, I think that's preferable than trying to do it than litigation at this point. I would I'd recommend that as a board we modify the directive we gave to Mr. Nibs to afford him some time to work something out with the new executive director of WAP.
Chair, how much time did you have in mind to make this modification?
I don't know. I mean, that's something we could talk about. I mean, but obviously we need to give it enough time for him to be able to make an effort, but also keeping in mind our need to have the cash in the door. So yes, Mr. Nibs, what would you think be a reasonable time? I mean, if you're in his shoes, what would you think be a reasonable time to?
Well, I would think I give him 10 days to come up with payment on the employee portion. I would think give him another 30 days and just give him some room. He said he needed, and none of his staff was there. He was there by himself. I asked, you know, if the other staff were going to attend, no one else was there with him. I would assume he had to go back to the CFO to determine the cash flow situation. So I would say, give me some room for another 30 days to see if we can come up with some type of middle ground. I offered him a payment plan of 12 months. So I want to see how he's going to respond to that.
So, so right now, the directive from the board in the form of I think it was in the form of a motion was what?
Okay. Well, that was
basically that the administrator was given 60 days to enter in from, I believe it was September, to enter into a payment plan with WAPA or initiate legal action. That was the gist of the resolution.
Okay, so he was given 60 days to enter into a payment plan.
Yes, for the parties to enter into a payment plan, or if that wasn't effectuated, then he would initiate legal action against WAPA.
Okay, so I said, Mr. Nibs seems to think that 30 days is a reasonable amount of time for him to work out a payment plan. I would like the board to give Mr. Nibs that 30 days, I guess starting today, to work out the plan. So we'll in effect extend the deadlines that he had for 30 days. Another 30 days starting today.
But Chair, I would just say that I hear Mr. Nibs, I hear you, Chair, and I hear the Council Williams. I really see a difference between now and the 30 days. But I mean, if the majority of the members would like to do that, I will support it today. but I don't really see a difference. I think what's happening at the Water and Power Authority, it's just a management issue with their financial resources, mismanagement of the financial resources and the human resources. Because as I said, when we made the initial resolution, and this is before even Mr. Smith, the new acting executive director, came on, they were hiring at the highest levels. So they have money. It's just they're choosing how they want to spend their money. It's not like they don't have the money. They have the money. They've always had the money. It's been just a continuation of mismanagement of the financial and the human resources at that authority. So as I sit here, my interest is just to get something done. And now Mr. Nibbs indicated he had a meeting and only one person showed up. And then the people who probably should have been there to help this new CEO wasn't even in the room. So I'm not sure how serious they are, unless that's the new CEO's style since he just come. But I mean, if you guys want to do that, I'm going to support it today, but I don't see a difference in the next 30 days. I think we'll be right back here again. We've already gave them over 60 days. Nothing has happened. So I don't think if you're running an operation like this, it shouldn't be one person that's going to stop the show. You have people who you're paying at the highest levels in the system who have a job to do. There are people in there, whether Mr. Smith is here or not, to pay these bills. That's their job. And there's some kind of law when you're extracting people's monies for retirement and you're not paying it where it needs to go. I know there's some kind of laws against that. I just can't quote what it is today, but I know that's not legal as well. And they're not strapped for cash like that. They're paying individuals in there, which is public knowledge, promoting people, including the legal counsel side of that system. So they have money. I don't think that's the issue. They're just deciding what they're going to pay, and they're squeezing us. And I disagree with Mr. Nims as to what they're helping us or not helping us with on the dock. They have obligations with that as well, because at the end of the day, those employees are part of the same retirement system. So I'm not going to mix those apples and oranges and believe that we're here requesting something that we're entitled to from a weak position. We're not in a weak position. I'm not going to sit here and say the system is in a weak position, because we're not. The people need to pay us.
Okay, all right. So do we need a motion, Mr.?
Yes, Mr. Chairman, somebody would have to make an appropriate motion.
Okay, so.
I mean, assuming they want to do what you're suggesting, an appropriate motion would be that we amend that resolution, and I don't have the number, to grant the administrator an additional 30 days to effectuate a settlement agreement with WAPA or to initiate legal action.
Okay, could somebody make the motion?
So moved.
How's that?
So moved.
Moved by whom?
Trustee Dorsey.
Oh, okay, so we have a motion. You get a second then?
Second.
Moved and seconded. Roll call.
Trustee Carwood,
Yes.
Trustee Dorsey,
Yes.
Trustee Liger,
Yes.
Trustee McDonald, absent. Trustee Russell,
Yes.
Trustee Smith, absent. Chairman Barry,
Yes.
5 yes, 2 absent.
Okay.
Mr. Nibbs,
Yes,
Mr. Chair, can I inquire something about Mr. Nibbs regarding the recent amendment to that resolution, please?
Sure.
Yes. Okay, Mr. Nibbs,
Yes, sir.
you met with the new CEO. Is that an optimistic view of resolving and getting a MOU or some kind of document in writing, so that we could represent that we have something in writing that might be binding on them, even though, you know, short of litigation, you might need to a MOU with them. What's your feel on that, Mr. Nibs? Is that an avenue that you would pursue?
Well, I don't know if we need an MOU. The resolutions from the board, I think, is suffice. We just reiterate the same thing to him, what the board did, what the board decision is. You know, this gentleman is not an engineer. He's a numbers guy. His background is business, investments and all that. So he's not an engineer. So I think he understands the situation. Just give me some time. I mean, you know, he's supposed to respond to me in 26, and we go from there. But I don't think we need an MOU. I maybe, you know, I don't know what the legal counsel think about that, but the resolution is good enough to me.
If you get whatever agreement you guys come to, would have to be reduced to writing, right? You have to be.
Yes, we would enter into a payment plan with them and everybody would sign off on it.
Sure.
Okay, good. Well, that's good enough. And because, yeah, a payment plan, they sign off on it, that we could say that we did something to hold them accountable. And in the 30 days, we have some document in writing. Thank you. Thank you, Mr. Chair.
Okay. Okay. Okay, so next on the agenda is we're on the agenda, Mr. Nibs.
Yeah, person's
The
report.
person's report. Okay, I just have more a comment and a statement than a report. I mean, and I'd like to go on record as saying that I'm pleased and excited with the passage of Act number 8540. And that's the act. Its official title is the Matching Fund Special Purpose Securitization Act of 2022. But in my view, if it delivers on its promise, it ought to be remembered as the GRS Rescue Act of 2022. The act promises to provide significant additional contribution to GRS, approximately $4 billion over 30 years, which should be enough to sustainably fund the benefits of the system, at least as they're currently defined, for the foreseeable future. The GRS and the GVI have negotiated and signed a settlement agreement, which was required by the Act. And pursuant to that agreement, GRS agreed to drop all money claims and dismiss all pending litigation against the government upon the issuance of the GRS funding note. That's the instrument that guarantees the annual contributions to the GRS. So now it's the ball is in the executive, the governor's and his financial team to execute. So on behalf of the members of the GRS, I'd like to say special thanks to the plan sponsor, the government advisors for stepping up to the plate, particularly to the 34th legislature for its unanimous passage of bill number 340188, which was the result of an impressive amount of work that was done by the GRS subcommittee on finance, subcommittee of the Committee of Finance. Also to the governor and his financial team for its swift approval and all the other enabling legislation actions that they had to take. I'd also like to thank the members of the GRS board and staff for acting expeditiously to provide critical technical support and the required approvals. We think we are looking forward to a successful execution of the plan that will be benefit to all retirees. I think that was an excellent demonstration of collaboration between all the stakeholders in this issue. And I'm looking forward for it coming to fruition. That's basically my report. Administrator's report.
Oh, before that, I would like to comment a bit about the whole process. I think,
Sure, go ahead.
yeah, I too think that it was a lengthy process that was long coming. And I'd like to give GRUF, Government Retirees United for Fairness, credit regarding the passages of that bill. GRUF started the proposal to have the ROM cover over dedicated to the GRS. It went through many different avenues and channels and revisions, passages of laws and, repealing a law. But I think in the long run, the dissension that GRUF offered and then their input to this, I think achievement, it's a good achievement for the government and should be noted. And then we should note also that our staff, I think our legal staff provided valuable commentary, and I want to congratulate them because when we went to the final analysis of the bill, their contribution was significant considering how long the bill has been around, the idea and the bill has been around. So congratulations to everybody who participated in it. And hopefully we have crossed that hurdle of making the GRS solvent. And hopefully that the administration would live up to the dictates of the law. And I commend you, Mr. Chair, because you supported it, and we did a good job, I think, protecting the system on the whole, and we should congratulate our staff and ourselves and the whole government system that really promoted the bill and had it passed. Now it's for the government to honor the proceeds coming to the GRS. Thank you, Mr. Chair.
Thank you, Trustee Russell. I think I did mention the staff in my comment, but if I didn't, I'd like to put a detail under your congratulations, staff. I also particularly like to, which I didn't mention, the GRUF contribution, and I think the activism on the whole has been played a key role, a key part in getting us where we are today. I mean, there have been an active group, and not just with this issue, but all other issues that affect the GRS. So, yeah, I'll add my congratulations.
Chair, I just had a quick comment as well. Has this process actually gone out to market as of today?
I don't know as of today, Trustee Dorsey. I mean, I had a note to call Mr. Paul, who is the lead coordinator at this point, and I didn't get to that, so I don't know if it went out today. I do know that they had indicated that they wanted it to start like yesterday, and that's, you recall when we were discussing the settlement agreement, that he had expressed the importance of expediting that. And I think what's driving the time frame is is the expected increase in interest rates. I think the Federal Reserve is supposed to meet in March. The next meeting is in March. It's widely accepted that they will take actions to increase interest rates. And so we wanted to get our deal done before interest rates go up. As you know, interest rates go up, and debt service goes up. Debt service goes up, the amount available, the GRS contribution goes down. So that was the driving force. So I assume they're full speed ahead, but I don't know what the status is precisely, Trustee Dawson.
Well, I guess, Chair, one of my reasons is looking at world events, and we have a war that could change a lot of dynamics of what we think we're looking at right now. And we just need to get to market if we're going to do this thing, because this is beyond where we're at in terms of interest rates, because once the war kicks in, that changes the whole dynamics. And I'm not sure if people are watching that or just listening to the two heads of states communicating about if they're going to do it or not do it, and if they're going to do sanctions or not do sanctions. But anyway, the other item I wanted to ask about with this entire package, at some point, will we get an opportunity as trustees to look at the package, the entire package, what's going on with this special purpose vehicle in terms of the relationship with the bonding portion of it, as well as the issuing of the bonds, as well as the agreements with the first organization in line, which would be the rum companies, the two rum companies, because we're giving up a lot as a system. We're giving up these items we have in the court saying that the plan sponsor owes the system monies. But I would also like to see what the other individuals who are part of this package, because we're supposed to be all in this together, also had given up to redo their agreement. So I'd like to know what they gave up as well, not just what we're giving up. I'd like to see the entire package.
I'm sure you'll see a package, but it won't be before it's implemented. I mean, that process that process right now is solely in the government's realm. That's going to be happening between the government financial team and the bondholders. We won't be able to interject into that. I mean, our safeguard is the legislation. As long as I stick to legislation, then that's our safeguard. But I can't imagine, knowing how that process works, I can't imagine a situation where they'll come back to us before then. I mean, those are decisions that have to be made almost instantaneously as people make offers. So,
no, Chair, I was just referring to when it's all said and done. I would just like to look at the package, have access to just see what the entire package looks like when it's all said and done. Meaning
I'm sure we'll see it when it's all said and done. I mean, yeah.
Okay, thank you.
Okay. Okay, can we move on? Kathy, is your people available?
Mr. Chairman, I think I saw Jonathan walk on the line.
Okay, and he's with whom?
JLL.
Okay.
Yep, I'm here, Mr.
Yes, I'm sorry. My configuration is different because Mr. Nibbs is still sharing his screen. But yes, Mr. Walker is on the line now. So we need to go into executive session.
Okay, could I entertain the motion to go into executive session, please, as we agreed to?
I move that we move into executive session to deal with the lease and unfinished business that the need is necessitated for protecting the according to the protecting the interests of the lease and keeping the proprietorship of anything confidential. So
Discuss.
I so move.
Okay.
Second.
Move in second then.
Trustee Calwood,
Yes.
trustee Dorsey,
Yes.
trustee Liger,
Yeah.
trustee McDonald absent, trustee Russell,
Yes.
trustee Smith, absent, Chairman Barry,
Yes.
5 yes, 2 absent.
Okay, so we're now in executive session.
Excuse me, Mr. Barry, can I get about 2 minutes to clean the room and end the